Welcome to Meidas Touch Legal AF. If it's Saturday, it is Legal AF Live. If it's Sunday, it is Legal AF. Rain or shine, holiday, no holiday. Ben Meiselas, Michael Popok here for you. I don't know if you saw Popok, but the Meidas Touch brothers, those three brothers, they did like a Thanksgiving special. Me and you, we just keep it consistent no matter what. Every weekend, just delivering the law. The law doesn't stop, Popok.
We're like a locomotive. We just keep moving from station to station, and neither rain nor sleet nor dark of night are going to stop the delivery of our legal political news.
It's a funny thing, Popok, because in my career now, I divide my time fairly equally between the deal-making side of my law practice and the litigation side of my practice, but increasingly doing more of the deal-making. On the deal-making side, Thanksgiving begins like on Monday, before the Thursday. And as I've gotten more and more into that world, I found it so surprising because on the litigation side, litigation doesn't stop until literally the holiday. And even on some holidays, you're getting those federal orders that are coming in on the electronic filing system. You know, litigation doesn't stop at all. And one of the annoying things about being a litigator, and all the litigators who are listening know this, I always hate when I have an opposing counsel who just tries to intentionally make your holidays annoying by like filing some motion that requires a response.
Christmas Eve.
And, you know, it's mutually assured destruction. Popok, maybe talk our listeners through, though, holiday collegiality in the law practice, because I think it's important. And when you practice law at the highest level against really good litigators on both sides, one of the things you notice is the process just goes so much smoother sometimes. It's like two good boxers who go into a ring. You're not just swinging wildly like, you know, two people who'd be fighting in a bar who are drunk for the first time. But what's always frustrating is you don't always get to pick your opponents. And sometimes you just get this lawyer on the other side that's trying to either make a name for themselves or it's just very difficult, who makes every little thing annoying, and then you make their life annoying, and it's just mutually assured destruction. So Popok, maybe give some of the background on just holiday collegiality in honor of the fact that we're post-Thanksgiving.
Yeah, I think in my 30-year plus career, it's changed over time. I think when we're litigating, when you and I are litigating against, you know, sort of our equals in terms of stature, in terms of pedigree, if you will, you know, sort of like the elite firms that you're talking about, there still exists a certain amount of collegiality. I'm not going to file at midnight on Christmas Eve. He's not going to file, or she's not going to file on the eve of a Jewish holiday that's important to me. And if they do it by accident, like I've had people say, hey, let's have a very important status conference phone call on Yom Kippur, which is the highest Jewish holiday. And I'll say, that's like not a good day for me. And they'll be like, oh, sorry, we didn't mean to do that. And thanks for telling us. I've had other lawyers, and usually it's the ones that, you know, don't have great records or practices, and they try to get every little advantage because they think sharp-elbowed practice is the way to success. You and I have never won a case by being an asshole in an email exchange or on the telephone outside the presence of a judge. Cases are won and litigated in courtrooms with a person in a black robe. And so I'll get a young lawyer or an inexperienced lawyer or an unprofessional lawyer on the other side, and I'll try to school them, but politely, sort of like what we do in LegalAF, polite schooling. And I'll say, listen, I don't know how many cases you've tried, but I've never won one of my 40 trials on a phone call. I've only done it in a courtroom. So why don't we put aside all of this nonsense and be collegial where we can be? There's positions that you and I are going to take in a case on discovery, on depositions, on scheduling. But if I can give and extend courtesy, which I'm supposed to do as a professional, I will do it as long as it doesn't disadvantage my client. Sometimes a midnight filing to get an injunction to stop something from happening has to happen. And it has nothing to do with I'm trying to gain an advantage or I'm trying to, kind of royal the other side. I just have to do it because it's important to my client. Other than that, you and I do our best work in a courtroom when you're not a transactional lawyer and you're doing what I do and not trying to gain the upper hand by being, sort of an asshole.
Popok, well said. I thought that was an important moment to talk about that side of the law as we move past Thanksgiving and we head into the holidays, especially for all of other lawyers listening to this or young lawyers who are listening to this to learn about really what is important, in the practice, which is ultimately succeeding in the courtroom at the end of the day. And there still should be a level of collegiality and at least a modicum of that existing in our profession. We're going to be talking in this episode about protective orders on this podcast. We're going to talk about protective orders in the context of the ongoing criminal prosecution of Steve Bannon a little bit later in the podcast. But we're also going to talk about protective orders now in the context of the investor lawsuit against the Trump family in connection with the kind of marketing scam that Trump was embroiled in with this American Communications Network. This was this multi-platform marketing gimmick where people would pay hundreds and hundreds of dollars because they believed they would be salespeople like Trump and the Trump family, allegedly, although we saw it. And if you ever saw those magazines on the airport, on the airplanes, I remember you'd see them with Trump like advertising these ridiculous things like be a billionaire like me by selling, whatever these items
Trump
are.
steaks. Remember Trump steaks?
Trump stakes, but Trump tried to get this investor lawsuit in this multi-platform marketing scam into arbitration. About a year ago, that failed. So it's been proceeding through federal courts. And now recently, there was a motion by the attorneys for the victims of the scam to look at footage from The Apprentice. The judge has allowed the lawyers to look at it. And why I say we're going to be talking about protective orders, though, is that one of the strange things is that while these courts and federal courts and state courts are open to the public, there's what's called confidentiality orders or protective orders in litigation, which sometimes protects what the public can see and sometimes even what the clients can see. Sometimes there are provisions that say, first, only the lawyers can look at highly proprietary information, and that's what's called attorney's eyes only. There are some orders where a judge says only the attorneys can see it in very rare circumstances. Often that's the case where you have like the secret ingredient to Coca-Cola, and that they're worried that if one of the litigants looks at the recipe, they could use it for anti-competitive purposes, but that's, on the more rare side. But the confidentiality generally protecting business secrets, health records, although I think, and you probably have seen this, Popok, in your practice as well, protective orders to me have been abused more and more and more and have been trying to make all public litigation private, and different judges have different views on it. But that's suffice to say, there was a battle over what documents could be released in this specific case. And ultimately, the lawyers for the victims are going to be able to look through and comb through some of this Apprentice footage. So Popok, tell us what's going on here with this Apprentice footage, and why is this important to the investor lawsuit?
Yeah, it's an interesting case, but let me preface it by giving a little bit of my own personal observations about Trump in New York. I have to tell you, the people that live in New York and watch Trump's entire career are sort of gobsmacked that he got as popular as he did, as being some sort of business guru, and was able to slap his name on the Celebrity Apprentice to keep his name and his brand alive all those years. Because in New York, people that really knew him and followed him thought he and his family were sort of a joke. They had already gone bankrupt 3 times. He's the only person I know of that could find a way not to make money in the casino industry and go bankrupt, and have a federal bankruptcy judge put him on an allowance, a monthly allowance. He was sort of a middling developer, not one of the top 5 or even top 30 developers in New York at all. He was a very good promoter of the brand. He was very good at slapping the Trump name on buildings that he did not himself develop. And neither did the children. And it was a small real estate firm where everybody had the Trump last name. It wasn't a big company. So, but he was listen, we know he's a charlatan. He was able to convince people in middle America and other places that he was some great business person. And he used that celebrity to market things with his children, because they're also sued in this lawsuit, this 2018 class action case, where the investors of ACN, which sells cell phones and phone service and voice over internet cards and all of that. And if you put $499 in, you're supposed to reap back tens of thousands of dollars in return, which was a total joke. And as the plaintiff's lawyers have alleged, a pyramid scheme where nobody got a return. There's one person who's a plaintiff in particular. She put in $5,000. She got back $38 in total return on her investment. So this is the case you and I talked about 6 months ago, where the first thing that the Trump family tried to do was to drag the case out of the courthouse, out of public litigation, into arbitration. Not arguing, not that they had an arbitration agreement that they were trying to enforce, but trying to join behind the fraudster, which is the American Communications Network, the alleged fraudster, who had an arbitration provision with each of the investors, and Trump jumping up and down and saying, "Hey, me too. They have an arbitration agreement. I'm very closely aligned with the party that defrauded all of these investors. And so I want the benefit of the arbitration agreement also." It was a weird, you and I commented on it 3 or 4 podcasts ago. It was a weird thing to try to align yourself with the company that is alleged to have committed the fraud in order to get the benefit of the arbitration agreement. Well, the judge in the case is the same judge here, Lorna Schofield at the Southern District, New York Federal Court, said no. Second Circuit said no, and it didn't go up to the Supreme Court, or wasn't reversed. So the case is back in front of Judge Schofield, who just as a little bit of a shout out to her, a 2012 Obama appointee and the first Filipina American or person of Philippine descent on the federal bench at the highest level, an Article 3 judge. So she was a partner in speaking of elite firms that you and I have litigated against. She was a partner in a very elite firm and handled very sophisticated litigation before she was nominated and put on the bench. So MGM was the producer of The Celebrity Apprentice. They have all this outtakes and other footage that never got onto television. And what the plaintiff's lawyers, in a very creative approach, are saying is, perhaps, Your Honor, in those outtakes, in those moments when there was a hot mic, when Trump and his children were waiting for the cameras to roll for the scene that ended up in the episode, maybe they commented about the American Communications Network and perhaps indicated that they didn't think it was a legit organization either, although they got paid. It looks like Trump got paid at least $8 million or $9 million between 2005 and 2015 from being a spokesperson, along with his children, for this entity. The interesting thread here today is that the same lawyer that's representing the plaintiffs in that case is the same lawyer that's representing E. Jean Carroll, is the same lawyer that's representing the plaintiffs in the Charlottesville case. So just as you'll hear us talk about these sort of weirdo, wacko lawyers that are representing Trump and all of these attempts to turn over the election or overturn the election, there are lawyers on the right side of the angels that are taking cases against Trump in different jurisdictions and are finding great success. So we're going to see. The lawyers have now gotten over the objection of Trump, have now gotten or about to get the MGM outtakes. And maybe there's something in there where Trump whispers to his child, like, "Oh, this is such a bullshit company. I can't believe we're doing this and they're paying us for it." And that will be really helpful to the case if they find it.
I think so, Popok. And I mentioned the protective orders as well, because our listeners are probably saying, and viewers are saying, well, do we get to see the outtakes? Not yet. if this ultimately goes to trial and the evidence is determined to be reasonably calculated and relevant and admissible, then you'd probably see it in the context of a trial. But at least for now, that's not something that would be released publicly, as there's a protective order in place there, and those records from MGM would be confidential records, whether we like to or not. Now, here's a potential I guess, mission that we could put Meidas Mighty to think about, or other lawyers out there. Any third party, though, can intervene. A member of the public can intervene in a case. You listening can actually intervene in a federal case, and I'm not suggesting you do this here, though, and basically say, as a member of the public, as someone who is reporting on this or who wants to know about this information, I don't think that this is a private information. I'm a member of the public. Disseminate this publicly. Now, you may get laughed out of court, or you may be warmly embraced by the court, but media does that all the time. They'll intervene in cases and say, de-designate certain documents so that the public has a right to know. Moving on Popok, to the settlement reached with the Parkland shooting family. Parkland shooting family, the victims' families reached a $127.5 million settlement with the United States government over the FBI's inaction. And look, there's not a single dollar amount that you can place on the value of any, human life, but a settlement of this proportion in a case involving inaction by a law enforcement agency is not only just rare, but really one of the first of its kind. Generally, what the law says on these issues, state and federal, is that where a law enforcement agency undertakes a duty to protect, and where there is a foreseeable harm to the victim after undertaking this duty to protect, where the agency then places the victim in a more dangerous situation and essentially causes the harm, in rare circumstances, law enforcement agencies can be held responsible. I'm oversimplifying the law there, but that's generally what these two doctrines basically say, for where inaction becomes viewed as affirmative types of action where the law enforcement can be held responsible. But generally, the Hornbook law, the basic law, says you can call up the police and say, hey, I need help. And if they don't do anything, you can't sue them for it. Whether we like that or not, that's generally what the law is. Inaction is not something that law enforcement can be held responsible for. So what happened here, Popok?
This is a fascinating case, and it just shows you what happens when elections do have consequences. We say that, and it's not a trite phrase. We mean it to mean a lot of things. And what we mean it to mean here is, on the heels of the $88 million settlement of the Mother Emanuel AME Church and the victims of Dylan Roof, who was an active shooter in that church just a month ago, and now a $127 million settlement with the there were 17 people that were killed at the Stoneman Douglas High School in Parkland in Florida, in South Florida. This is the Department of Justice. This is Merrick Garland. This is the Biden administration stepping forward to reestablish integrity and faith in the justice system that had been so soiled by Trump and by Barr and by Sessions before him. In my lifetime, I can recall on a half of a hand situations where the U.S. government took responsibility for things that they had, what you and I have talked about in the past, sovereign immunity protection from. Normally, what you were commenting on earlier, the exercise of police power by a government, whether it be a state, local, or federal, is usually protected by sovereign immunity in a lot of instances. And in general, there are exceptions to it. And so bad things happen to people sometimes at the hands of the government, whether it's in the military, friendly fire during military operations or exercises, and the families are left, of course, devastated and bereaved, to every other aspect of what's called the police power. And generally the government will say, unless there's a waiver of sovereign immunity where the government itself, in this case, the Congress or otherwise, waives sovereign immunity, you're sort of stuck if you're a victim. Here, the Department of Justice, even though it probably in the US probably would not have lost a lawsuit brought by the families at Parkland, as terrible of a tragedy as it was, they stepped forward and said, no, we're going to do the right thing. We did it a month ago with the church in South Carolina. We're going to do it here. And what was the misstep, or what was the omission that happened with the FBI? 5 weeks before the shooting, they were given credible information to the Miami field office of the FBI that Nicholas Cruz, the shooter, was planning a mass murder at his high school. Sounds like something they should have picked up, investigated, arrested, and detained. And that was enough for, again, Merrick Garland to step forward and make the recommendation that there should be a settlement at this level. Now, not everybody's settled. There's one family, frankly, that did not sue, and it decided that they're not going to sue. And that there's one person who was seriously injured who is suing separately. But this takes care of really almost the entirety of the victims of what happened at Stoneman Douglas. And again, I think it's an example, Ben, I want to hear your opinion about reestablishing the guardrails of democracy, of civilization, of the proper exercise and execution of our justice system in the hands of adults who are civilized, like the Biden administration.
I agree. And look, you could delve a little deeper here too, Popok. And so there was a motion to dismiss that was filed by the DOJ when Trump was in office. The judge on this case is someone by the name of William P. Demetrios, United States District.
Demetrios, I've been in front of him.
And a Clinton appointee, right? And issued a 44-page order on August 31st of 2020, denying the United States government's motion to dismiss. And basically the basis of the denial was that the FBI had created a public access line, a PAL, and the PAL was where these types of threats were to go to. And where the complaints about threats or where warnings were supposed to go to. And the threat line, it was directed to PAL, and PAL kind of sat on it. They didn't do anything. But for the existence of PAL, that information would have other went directly to the Miami field office directly, which then could have taken action. So the motion to dismiss order was based on the undertaking here was that when the FBI created this public assistance line, they basically invited the calls for people to give warnings and to give tips, and then by not acting on the tips, they created the problem. Now, what I think would have happened here, Popok, if this went one in front of a different judge, I think a different judge could have seen this the other way. I mean, they drew a judge who wrote a very detailed 44-page order, but if this was in some of the judges that we've talked about, for example, within the Fifth Circuit, some of the district judges in Texas, I mean, this would have been dismissed, not in a 44-page ruling, probably a 1-page ruling, basically saying either one, you can't even sue the government in this type of case, and two, there's absolutely no duty. I could have seen a 1-page order just going that way. I also think that on appeal, this order would likely get overturned. And I think even in front of the Supreme Court, this order would likely be overturned. But you're right. It's the DOJ restoring a modicum of civility, of dignity. And they made the decision on their own and said, look, we could probably win this case. We could win this case. But at what expense? We could win this case and further traumatize the families when we know we were wrong. Maybe we were not technically legally wrong based on the way our law has developed, but let's do the right thing here.
Well, here's a theme that you established at the start of this podcast. You can do certain things, but should you? I mean, there's tons of things you and I could do to drive somebody crazy on the other side, but I'm not going to do it. And the government here, now in the hands of adults and civilized people, like you said, yeah, we can win it, but should we? There is a morality that is baked into our legal system that was lost for the 4 years of the Trump administration. One comment about Judge Demetriou, who I've been in front of, and I think this helped the case. Not only a Clinton appointee, but served for almost 10 years on the Broward County Circuit Court in Fort Lauderdale, and is of the people and is of the community and probably knew people in Parkland, which is a small town in Broward County, before he got appointed after about 10 years onto the federal bench, and takes that job seriously. He's got a nickname. His nickname is Fast Billy because he does things really quickly. He puts the government and the defense on their toes. You know, he moves cases along very, very quickly. It's a rocket docket that exists there. But he's also a human being that lived in that community, and I'm sure that impacted his decision making in the right way. But you're right. That was one example of the Department of Justice under Biden and under Garland not adopting the positions of the predecessor Department of Justice where it really matters.
This podcast is brought to you by Calibrate. Want to tell you about a time where we've all gone through these weight loss fads or these different gimmicks, and they don't work. And I think about that now as we just finished Thanksgiving, and I'm sure we all had some great meals, but we're all thinking about what that is. But Calibrate is not a diet. It's not a quick fix product. It's a year-long commitment that gives you the tools to fight your biology. And we know that traditional diets don't work because you can't fight biology sometimes with willpower. And this is why Calibrate is different. It is a comprehensive, doctor-guided metabolic reset that promotes sustainable results through lifestyle changes. And it works because Calibrate combines a doctor-prescribed, FDA-approved medication paired with lifestyle changes to improve metabolic health. It's comprehensive, fully integrated program combining classes and one-on-one video coaching, in-app tracking, and a community of members like you makes this work. Plus, medical care, including a video doctor visit. Calibrate's earliest members, Popok, lost an average of 14% of their body weight, exceeding the 10% average weight loss results seen in clinical trials. And over 20 years of research shows that a combination of GLP-1 medication and coaching can improve metabolic health and drive long-term sustained weight loss. And they provide a comprehensive wellness plan that is personalized to your needs. Your weight doesn't reflect your willpower. Get back in control with Calibrate. Get $50 off the 1-year metabolic reset when you use promo code LegalAF at joincalibrate.com. That's $50 off when you use the code LegalAF at joincalibrate.com. That's joincalibrate.com. Go to joincalibrate.com and use that promo code LegalAF. This is an incredible product that combines all those aspects, which I think is where a lot of, where we need to be going with this, which has combining technology, with this kind of great product. So Popok, I want you to also talk about some repercussions though. We talked about what can you do, what should you do. Now let's talk about what you should definitely not do, which are these lawyers. I don't know what they were thinking. They probably weren't thinking anything, but these lawyers who think that the Trump, crew is going to protect them. They're all one by one getting serious sanctions for their bogus lawsuits that they filed at the behest of Trump and Giuliani and all these people. They're paying real sanctions now and losing their licenses. And I'm glad that they're having these repercussions. But tell us about the recent update in Colorado.
I think what you're observing is a group of lawyers who decided that their own fame and fortune and to raise their own profile, they would sort of do anything, and they would sacrifice their professional license and their ethics in order to get notoriety to help them and publicity to help them in their careers. Because no one ever heard of these lawyers outside of maybe their hometowns. There's two Colorado lawyers, Gary Fielder and Ernest Walker, no one ever heard of, who decided to jump on the Trump bandwagon, probably promoted by other lawyers like Lynn Wood and Sidney Powell and all that. And they filed a case in Colorado against Dominion voting machines, voting systems, Facebook, and the states of Michigan, Georgia, Pennsylvania, Wisconsin, in Colorado. Okay, our LegalAF alumni, soon to be graduates, know enough to start scratching their head about, does a Colorado federal judge have jurisdiction over the states of Wisconsin, Georgia, Pennsylvania, Michigan, and the governors of those states about the election? And if you're scratching your head and wrinkling your nose, you're on the right path, because the federal magistrate judge, and we'll talk a little bit about magistrates versus Article 3 judges, trial judges at the top, and when decisions get made by the magistrate judges and their effect. The federal magistrate judge here took a look at this case 2 or 3 months ago on a motion to dismiss that was filed by Facebook, by Dominion, and by the others, and said, not only are these cases without merit, but the fact that they were filed by Colorado bar members who are members of the federal bar should give everyone pause. And I want to send a message as a magistrate judge that if you're going to sign pleadings and you're going to allege facts and you're going to defame parties like Dominion Voting Systems by paraphrasing tweets from the president about alleged fraud in the voting system, that there's going to be repercussions and serious repercussions, and you're going to have to pay money related to that under the court's inherent authority and power to sanction under Rule 11 of the Federal Rules of Civil Procedure. So the magistrate judge here, Magistrate Judge Reed Nuremberg, had already found that they had violated Rule 11 by bringing a meritless set of pleadings. And in the actual sanction order that just got issued earlier in the week, in which he ordered the two plaintiffs' lawyers to pay $187,000 in legal fees for all of the parties that they sued, the quote that stuck with me, Ben, from the order is the following. The judge said the lawsuit that was filed was used to manipulate gullible members of the public and foment public unrest, and was an abuse of the legal system and an interference with the machinery of governance. And it wasn't going to be abided by him in that courtroom. And so he threw the book. I'm sure there'll be a bar referral to the State Bar of Colorado, if there hasn't been already, related to these two individuals, because they went beyond the pale of bringing cases for the good faith extension of law or based on existing law, which is the fundamental first step of any lawsuit that's filed. You and I don't sign a lawsuit at all under Rule 11 or under the state law analogy, unless, having done our research and our good faith investigation, we believe the claims have merit under the current body of law or a good faith extension of the law. And that gatekeeping that professional lawyers like you and I do as officers of the court, which is what you and I are. We're an officer of the court just as the judge is, just as the bailiff is, just as the prosecutor is in a criminal case. And you have to take that seriously. You can't just wipe your backside with a pleading, sign your name to it, and file it in court, especially in federal court, and not suffer the repercussions. So we saw it with Lynn Wood and Sidney Powell getting sanctioned. We see it here in Colorado. It's a good thing. It's a good thing these things are happening. And if judges don't draw the line in the sand now and do this, it's just going to invite more meritless cases to impact the gullible and foment in the public and foment public unrest.
Talking about wiping your behind with legal documents and just putting it out there. What in the hell did Mike Lindell? Did he even file this document? He just posted a document that appeared to be addressed to the Supreme Court, where it basically said, insert your name here versus insert their name there. And then he posted it. What in the world is going on there?
All right. Well, first of all, that was a very good transition. We recalibrated. That was very good. I liked it. So Lindell the pillow guy has been threatening or bragging since the election that he was going to get a lawsuit that was going to overturn the election. And when all the hundreds and hundreds of other lawsuits that were filed in all the battleground states failed and failed miserably, like 70-0. And the Supreme Court even looked at these cases and said, no, we're not overturning the election at this late date. A pillow guy chooses an even later date. We're now November. We're almost a year after the election. We're a year after the election, which has another problem. It's called timeliness of filing your suit. And he said, I'm going to file or have a suit filed on behalf of one state against the U.S. government and the Biden administration. And that case, let's make this a teachable moment, and we'll have some value of this pillow guy Supreme Court case that's not happening. There is original jurisdiction that the U.S. Supreme Court has over a limited type of case. Normally, the Supreme Court of the United States hears appeals. That means a trial judge at the lower level tried the case, or an appellate court below the Supreme Court issued a ruling, and then as the ultimate appellate court of the land, the Supreme Court jumps in. There are small exceptions where the U.S. Supreme Court has original jurisdiction to hear a case as if it were sitting as a trial court. And that is if a state is suing another state. If New Jersey sues New York, they can go right to the Supreme Court to have the case tried instead of to the lower level federal court. And if a state sues the U.S. government. So Lindell, who couldn't get any state, even the ones controlled by Republicans, to file this lawsuit overturning the election and claiming fraud in Wisconsin, Pennsylvania, Michigan, and all those other places, just had some lawyer, and Reuters, the news service, did a good job of researching the metadata within the brief that was posted, the complaint that was posted on Mike Lindell's website, and they figured out which lawyer it is. It's a lawyer that sits in Washington who's been ghostwriting a lot of these things for Trumpers, and they already outed him in their reporting, and I'll post that on my Twitter feed. But in this bill of complaint, which alleges that there was, mail balloting is fraud, is rife with fraud, with like no examples. That electronic voting is really bad, with almost no examples. He could never get one of the 5 states or any Republican-controlled state to join into the pleading. And he blames, of all people, the chairperson of the Republican National Committee, which is Ronna McDaniels, which is Mitt Romney's niece. He blames her that she phoned all these governors and these attorney generals in all these states and put a kibosh on the filing of the suit. So I'm going to post it on my website. And instead of having a press conference about it, he had a 96-hour, I'm not making this up, pillow and slipper-a-thon. It was a sales event where he barely talked about the suit at all. All he did was try to push his product. But the interesting thing is here, you and I spent a lot of time talking about, DeSantis and the attorney general in Florida and Georgia and what's happening with redistricting. They couldn't even get DeSantis's attorney general to sign on to this thing. That's how poor it is. And so it would be rejected like dead on arrival. The U.S. Supreme Court has already declared for the Biden election, they are not overturning this election. It is too late. There's no facts that support it, and they're not going to overturn the will of the people. So why Mike Lindell, other than to sell pillows and slippers, keeps pushing this to roil up the gullible masses of Trump supporters is beyond me.
I'll tell you the answer, though, Popok. The answer is because, as we've talked about on prior LegalAFs, well, here's one reason. He's actually fucking crazy. Okay, that's number one.
All right.
But number two is, if there were to be a logical explanation within this morass of craziness, it's that he's being sued for defamation by everyone. And so by continuing down this path and trying to get some governmental authority to sign on to his crazy theories, he could basically have some government entity co-sign it. So in his defamation cases, he can basically say, look, I've got the governor of X basically who's agreeing with me, and I've got this person who's agreed with me. And so this is kind of part of, it's kind of the never-ending scheme that they've got going on. And they don't even think one step ahead. Like, all they basically think, and this is kind of Trump's whole plan too, is like there is no end game in a lot of his crazy lawsuits. The end game basically is just every day, just create enough craziness and chaos and turmoil and just delay. And hopefully through all that chaos, people just forget about it and they move on, and then just blame the deep state or blame whatever. That's the plan.
Yeah, I agree with you. We talked about it before. When bad things are happening, make them happen slower. And that's what they're trying to do. But I found it interesting that despite all of the Trump acolyte lawyers out there, a lot of them getting sanctioned and some of them losing their law licenses. So I think that group, that little cozy club is shrinking. They couldn't find one lawyer, even the lawyer that ghost wrote it, who sits in Washington that Reuters outed. He didn't even put his name on it. It has, insert state name. And then it has where you and I would put, when we're proud because we're filing a case, and you and I
our names, you mean together, our names?
We would put our names in a signature block at the end. There's no signature block. So even the lawyer that wrote it was like, I don't want my name on that either. And then they couldn't find one attorney general. And look, I could think of a handful of them that are in the clutches of the Republican machine and the right-wing GQP machine in certain states, Alabama, Georgia, Florida, that would put their name on it and maybe get their state to do it. Even they didn't do it. So I get your point, but having not been able to get one of anybody to join him, why he posted it, on his website as this is it. It's because he promised it. I'm going to overturn the election by Thanksgiving. And when that didn't happen, just like JFK Jr. is not showing up at Dealey Plaza or wherever the people were waiting for him.
They're still waiting for him out there. Did you see that?
Yeah, it's totally. I mean, this is a cult, but there's one thing we're going to talk about later when we get to the Arbery trial. I don't know if you saw the polling. Almost 70% of Republicans think that the 3 defendants in the Arbery trial should have been let go and not found guilty of murder against Ahmaud Arbery. And of course, 98% of Democrats think that the verdict was just, but 70%, it's the same percent that to this day think Obama is a secret Muslim.
But here's the thing, Popok, and this should tie it all together, though, because I don't know for a fact what I'm about to say, but I could pretty much with great assurance say that on that Ahmaud Arbery jury, because you don't directly ask their political affiliation or if they voted for Trump or whoever, I can almost guarantee you that you had at least 1 or 2 members of that jury, who mostly all white jury, who voted for Donald Trump. And what this means and what the data you're telling us means, Popok, that 70% think that the killers of Ahmaud Arbery were not guilty, tells you that they're not getting their information from reliable sources. But the fact that a unanimous jury found the 3 murderers guilty on all counts shows that when they sit there and they're presented with the accurate information and they're given actual facts versus the lies, that the actual facts can prevail. And that's also why a lot of the GQPers, to go back to your other point, Popok, are not going through, not signing on to this Lindell document. It's not that they don't want to spread conspiracy. Oh, the DeSantises and the GQ peers, they're going to go out there and spread conspiracies, but they learned from this experience. We can't do this in a court of law.
There are limits.
In a court of law, we actually have to speak truthfully. Let's not do this in courts. Let's do this on the streets. Let's do this at rallies. Let's do this online. Let's do this on Twitter and Facebook. And let's just so brainwash people, because that's the only way we can get them. When we have to tell the facts, we'll lose all of the time. But which is why we need to protect our legal system. It's why we do LegalAF every weekend, because we need to fight for the system. Because what'll happen is, if the GQ peers can elect the disinfo spreaders to then take over the courts, then you get an entirely different outcomes than what we previously said.
And it's even, you're totally right. And here's why it's even more infectious, and why it's maddening on the Democratic side or the progressive side of the aisle, because it's disheartening over time. It becomes disheartening even to our own followers and listeners and Democratic supporters. I see the posts, and I can tell, it's almost like I'm reading a book now, but I don't know if you read this book by Malcolm Gladwell that's out now called The Bomber Mafia, about World War II and bomber technology and its impact and the morality of bombing on warfare. And one of the comments it made, one of the comments he made, one of the observations he made, was about Tokyo Rose, who was hired. It was a woman who was a sympathizer with the Japanese, who spoke perfect English, who constantly broadcasted over loudspeakers and over radios to the GIs who were in the war theater to make them lose their will to fight. She would just say crazy stuff to make them lose their will to fight. And my fear is that there's a Tokyo Rose going on with the Republican Party and its impact on the Democrats, and why you and your brothers, and in a way our podcast, is so important, because we're the opposite of Tokyo Rose. Don't lose faith. The democracy is not going into the trash bin. Okay, we're going to be able to reestablish the guardrails, but also don't cannibalize each other. Don't backbite about the Democrats and what Biden is doing. The numbers on Biden are low, not just because the Republicans seem to be down on him, but the Democrats are down on him. And we need a unity of party in order to continue to have Biden and the Department of Justice, do what it's doing now to fix all of the 4 years of damage. But don't let the Republicans get you down and Tokyo Rose you. Continue to fight and listen to the facts as presented on your podcast with your brothers, and what you and I do each week here about LegalAF. We have to arm everybody with facts.
Yeah, and I won't belabor the point anymore. But at Thanksgiving, and I was having a conversation with someone, and I was just like, you know what? Like, when you actually think about what Biden's accomplished in a short period of time with infrastructure, where the economy is, where the decrease in joblessness, the GDP growth being, now even recalibrated to like record-setting levels, like this is stuff that is fairly unprecedented, and yes, there is inflation. And Jen Psaki, said it. Yes, if you bought a 20-pound turkey, you paid $1 extra for that 20-pound turkey, which they're trying to address. But let's also think about the totality of all the other economic indicators that exist out there and what's going on.
You know what? On one last note on that. And that was, I had conversations around a table like that too. The biggest problem Biden has, and then I'll get off the political soapbox, is that whereas Reagan was the great communicator, to be frank, Biden's communication skills and the people around him that are, other than Jen Psaki, who we all love, he doesn't have great communicators around him. Kamala is not, for all of her things that I love about her as the vice president, she's not a great communicator. Biden talks a lot, but he's not a great communicator or message deliverer either, which means there is an open lane for Meidas Touch to help communicate the message. It's not that. What his accomplishments are, Reagan had half those accomplishments and is considered the great communicator and uniter of people. Biden needs to get better people in the White House to write speeches for him, to focus his message The press department after Psaki needs to be terribly improved, and the world around Kamala has to be changed out in order to have this message delivered properly.
Popok may be a guest on the Meidas Touch Brothers podcast. We'll see. We need to flesh this out a little more. This podcast is brought to you by Fiverr. Meidas Touch, we use Fiverr. The way we use Fiverr is oftentimes we'll need freelancers who can do voiceovers, or we'll need freelancers to prepare music for us for some of the background of the video. And Fiverr is like this incredible marketplace where you go on, and for small businesses, or really businesses of any size, you can basically go out there and identify this whole community of freelancers who go out there who could work for you on kind of a case-by-case basis. We all know how hard it is to make something out of nothing, and the thought of turning this idea into a reality really can feel overwhelming. But with Fiverr, turning that idea into something is easier than ever. Millions of freelancers across the globe help clients turn ideas into successful realities every day. And it's not just voiceover artists or people who help with do the music. It's experts in data, design, marketing, technology, website building, animation, and so much more are ready to help. You simply search for the service you need and set the timeline and price you want. And Fiverr provides you with a list of freelancers who meet that criteria. You can then browse their portfolios. You could read their reviews, know exactly what you will pay before ordering anything. And it's a simple to use platform. It has great customer service, I know from personal experience, and it has qualified freelancers in every field. So every successful something was once nothing. Head to Fiverr.com, and that's Fiverr.com, and turn that nothing into something today. Receive 10% off your first order by using my code, our code, not just my code. Sorry, Popok, it's our code, LegalAF at Fiverr.com, Fiverr.com. Again, that's Fiverr.com. Use the code LegalAF. I promise you it's something that you will use over and over again. What's the latest update, Popok, with the Steve Bannon criminal prosecution? So Steve Bannon wants documents to be made public. What was his lawyer arguing in court?
Yeah, just to remind everybody, so December 7th, everybody's going to be back in front of Judge Carl Nichols, the federal judge, pardon me, in the federal district circuit, the federal circuit in Washington, for a hearing which is going to set the trial, I believe, and also if there's going to be motion practice, like a motion to dismiss the indictment, that kind of thing, they're going to set the timeline for that. And he's going to move this case along very quickly. Just recall from last week, Bannon's lawyer said, why don't we roll this all off till January? Judge, you got a lot to do. You're sentencing Jan 6 insurrectionists. We don't want to step in front of that line. And the judge said, no, I can do two things at once. I'll see you on December 7th, and then we'll set everything related to the trial. What is usually not that objectionable, and I want to hear your opinion on this, is that at least in the federal court level, there's generally a standing order related to discovery. Parties don't even have to enter into certain agreements about how the discovery process, and even a criminal case has a discovery process where the prosecutor turns over information that it's developed in its interviews to the defense, and the defense, if it has exculpatory or other information that it will help the defense, turns it over to the prosecutor. And if there's witness statements that are developed usually by the prosecution, they get turned over. And this is all usually referred to as Brady material, and that sort of gets exchanged, but mainly it's coming from prosecutor to defense because of the burden of proof and the standard of proof that we have in a criminal case. And usually unobjectionably, there's a sort of a little bit of a cloak around and a little bit of a confidentiality bubble that's placed around the exchange of documents so that things don't leak out unless there's an intervention by the media or otherwise. On hypersensitive and sensitive materials that may be the subject of the criminal prosecution one way or the other. 9 times out of 10, 10 times out of 11, the defense and the prosecution has no objection to the standing order being put in place related to confidentiality, except when you're Steve Bannon, you have a podcast, and you're trying to litigate your defense in the court of public opinion of the right-wing radicals that listen to your podcast, and then you want chaos to ensue, and you want all the documents to be released and nothing to be privileged or cloaked in privilege. And then you file a motion, which they did right before Thanksgiving, opposing the imposition of the standing order on discovery, and then Judge Nichols is going to have to make the ultimate decision. I have a comment about Judge Nichols that I want to share with you, but I want to hear your view on confidentiality in criminal cases.
Let me break down confidentiality in this case, though, first, because the government previously said this case should go to trial immediately. And Bannon said, no, let's delay it. And the government said, why delay it? We're talking about 20 documents here. Yeah. We're talking about, the initial letters from the congressional committee to Steve Bannon, maybe the letters back. We're not talking about a whole host of documents. So
whatever he has about the Jan 6 planning and organization and leadership.
And so knowing that, for this case, for not showing up to it shouldn't involve the broader fishing expedition into all these other Jan 6 documents. I mean, it's literally, the case is Bannon was subpoenaed to be before the January 6th committee. He didn't show up for the Jan 6 committee. And so he needs to be held in contempt, and there's criminal consequences for it. So to me, that's so simple. Why do you need a protective order? I mean, it's one of the rare examples that I actually agree with Bannon's lawyer here, but not for the reasons that I agree with ultimately his underlying defense. But, if I'm the prosecution, I go back and I go, you know what? You're right. Let's make them public. But then let's also go to trial immediately. What I think Bannon is going to try to do, though, is Bannon wants to make this case about more than just the subpoena. What Bannon wants to make this case about is he's going to say, I need to delve deeper into the congressional intent here. What's really behind it? I need to understand. He's going to lie about this stuff. We need to determine what the FBI knew in advance. We needed to know. And so he's going to try to make this whole wacky conspiracy thing, do discovery requests on all of these kind of theories that have nothing to do with this.
Yeah.
Nancy Pelosi and all of these things. And then, the government's going to basically say, look, Judge, these things have nothing to do with the case. But if you do order that certain national security documents be released, we can't agree that those documents are inherently public. There may need to be documents that would otherwise be certain deliberations and other processes, which would be by their nature subject to a protective order. So that's kind of the view here. But here the government should say, sure, make these 20 documents public. Who cares? And then my overall view about protective orders generally is that I view that courts are open public forums. I think that unless the information involves like tax information, things about somebody's health conditions, private medical information, things that are truly proprietary in nature, actual business secrets. But like, to me, standard emails that get exchanged, those would normally be confidential. Those are the deliberations of businesses. I mean, to me, if you're in a case and there's a lawsuit going on, to me, that's fair game. That's public. I mean, a lot of those things are referenced in the allegations of the lawsuits. And I hate, especially imagine you're on the defense side, though. The plaintiff makes all these allegations against you publicly. You have emails to rebut it that you want to put into the public record. And then there's a protective order saying, no, you have to keep those documents confidential and the world can't know about those documents, that's ridiculous to me.
Yeah, I have a slightly different view. I mean, mainly from a vast experience on my side, on the defense side. I mean, in commercial cases on the civil side, I see a good argument why either in protective orders or something we haven't talked about, which is when you have the opportunity, when you file your pleadings or your motions, to redact, to use a black pen or the electronic version of a black pen to black out information that is you don't want it to fall into the hands of your competition, some sort of method or means or technology or way of doing business, or if you're not a public company, your internal finances as a company. Frankly, I don't want that all out there if I'm a defense lawyer, and I probably don't want it out there if I'm a plaintiff's lawyer either. So, I've been known in, let's say in Delaware, where redaction is taken really seriously, you get the opportunity, for instance, to redact a lot of the public filing of the lawsuit. Now, it's subject to the judge looking at your redaction and finding that it's reasonable. And if it's not, then making it public maybe a week later. But there is a period where it's almost like a cooling off period that some courts and some business courts use to allow for the initial redaction while the parties sort of, get into gear and start interacting with each other a little bit more, because some cases come out of the blue. Some cases result from failed negotiations over a period of time, and so nobody's surprised when it's filed. But some cases get filed sort of out of the blue. This gives the opportunity for the parties to say, let's have a settlement negotiation, or at least let's negotiate over what is confidential and what is not confidential. So I have a slightly different view than you. On the criminal side, listen, I don't know what Nichols is going to rule here, but I totally agree with you that the Bannon strategy is to widen the battlefield outside of his contempt and his failure to appear and his failure to testify and provide documents, and try to litigate through this as part of his defense to argue that he doesn't have mens rea or criminal intent, because either the investigation by the Jan 6 Select Committee is without merit, and they've gone beyond the scope of what they're allowed to do. And he's going to try to argue that from a kind of a jurisdictional attack on the Jan 6 committee, and then go further and argue that, the whole going after him is in bad faith, and then argue the executive privilege that he's exercising, or the cloak of it that he's trying to hide behind, is legitimate, gives him good faith to avoid criminal prosecution, and to do all that. I thought it was interesting that his dictated press release was that he wanted to avoid the confidentiality order because the public should make an independent judgment on the Department of Justice's fairness. That goes right to your point, Ben. This is what they're going to try to do. They're going to try this through his podcast. And then they also reference, well, the normal process is unfettered access to documents. I'm not sure that's the normal process. That's a process that podcast people and right-wing nut jobs would like the litigation process to be. But look, the good news is I've done a little more investigation on Judge Nichols. I tried to do it by reading opinions of his that touched on the Trump organization and the Trump decisions in the past. And listen, from what I'm hearing from people in the know, is that he is despite the fact that Trump nominated him, he is a balls and strikes right down the middle. He's not a right-wing crazy. So even though we were all sort of like disappointed that the wheel turned and by lottery, this Trump appointee was picked as the judge for Bannon, it may not be as bad as we thought. This person is really interested in getting it right, even if he's more conservative than we would have liked. We may be surprised by his decisions. And so far, he's been running a show that we can't take fault with in the courthouse.
And I go back to a Popok, if someone is legitimately conservative in what its old true meaning was, we may have disagreements over certain tax policies and certain views over climate, and we may have these serious disagreements. But what is scary is for the legal system is if the Mike Lindell GQP craziness creeps into the legal system. And so far, the legal system, in terms of the federal judiciary, has been able to, as a general matter, prevent that encroachment of the GQP craziness. But elections have consequences. I believe if Trump were to ever be reelected, or someone like a Trump would be reelected, it'd be over. It'd be over. We wouldn't even have LegalAF would be very different. It would be like Judge Mike Lindell is ruling.
Yeah.
It would be that crazy, because even someone like a McConnell and a McCarthy, as crazy as they are, as crazy as a McCarthy is, you may get Speaker of the House Matt Gaetz. You may get Speaker of the House
Donald Trump.
You may get Speaker of the House Marjorie Taylor Greene. I mean, that's where that could go. You may get speaker. Yeah, exactly. So Popok, I know that you've been using Aura Frames. This podcast is brought to you by Aura Frames. I love my Aura Frames. It's probably the best gift, one of the best gifts you can have for this holiday season. I use mine, but tell us about your experience with Aura Frames.
And I'm using it. I mean, this is like one of those hair club for men, and I'm a customer too. I'm using it right now. I'm on a little bit of a holiday, as you know, in South Florida, visiting friends and family for the holiday, and which is why my backdrop looks like another hotel room for Michael Popok. Because it is. And I took a series of photos of friends and family at Thanksgiving and just on the streets in Miami that I found really interesting. And while I was here, just using the app, rather than sending it first to social media and sharing it with, your select group on social media, I sent it directly using the app to the frame. Instantaneously, that picture, that video, that live feature went right to my frame back home in New York. And so I kind of set it and forget it. I loaded 22 new photos. And now they'll just be part of the rotation as I watch those, as I watch those frames, which I like. I tried an earlier version of, I won't mention the manufacturer, like 10 years ago. This was all the rage, these kind of digital frames. This one is really, really good. It's the technology that they use. It's the ergonomics of it. And it's really the simplicity. It's like Apple simple in terms of, being able to use it with the app and the integration with the frame, which I like. I really like a lot. And look, as we said before, it's beautifully designed. It's easy to set up. Even Popok was able to do it. And it's one of Oprah's favorite things, 2021, for 3 years running. And an Aura frame is the perfect holiday gift. You can even personalize it by preloading photos for a surprise that will have them crying tears of joy. And there's never been a better time to take advantage of Aura's best deals of the year. It's Black Friday, or it was yesterday. It's Cyber Monday coming up on Monday, Ben, through November 30th. So visit auraframes.com, AURAFRAMES.com now to get gifting. That's AURAFrames.com. And is there a listener's code that people could use at LegalAF, Ben?
Listeners, use code LegalAF to take $30 off Aura's best-selling digital picture frames. That's LegalAF. Again, go to auraframes.com, AURA frames.com. Take advantage of Aura's best deals of the year with those Black Friday, Cyber Monday pricing now through November 30th, plus that listener's user code LegalAF and take $30 off Aura's best-selling digital pictures.
Oh, sorry. Go ahead. Finish.
Were you gonna try to do a smooth transition, a Meiselas transition? Go for it. I don't want to step in the way.
Speaking of 30, there is a 30% off sale right now for LegalAF merchandise, mugs and T-shirts at the MeidasTouch store.
Oh, people love their LegalAF gear. People love the hold the house MeidasTouch sweatshirts. The MeidasTouch merch is flying off the shelves, Popok, and so order them now. I'm not sure we're going to have inventory if for the holidays, because they're basically all being sold out, but we still got inventory now. So if you go to MeidasTouch.com, you check out the merch, go buy your LegalAF merch, go buy your other MeidasTouch merch. Tons of discounts. We got discounts on ours. We got discounts on the MeidasTouch merch, but love seeing people wearing it. And I did Popok the other day when I was at another basketball game. I don't know why I keep going to basketball games. I did see somebody else wearing a MeidasTouch shirt, and I'm too embarrassed to go over to them and be like, hey, that's but I did see one person wearing a MeidasTouch shirt, and that was pretty awesome. Popok, what's also pretty awesome is some new January 6th committee subpoenas being issued for additional Trump allies, including Roger Stone and Alex Jones and others. I mean, Alex Jones isn't exactly having the best 2 weeks, but when you're a scumbag like that, you shouldn't be having any good weeks for the rest of your life. But what's going on here with these subpoenas? What should we be looking forward to? And, are we moving towards, progress here, Popok?
Yes. There's three things in Jan 6. This is our Jan 6 segment. We need a jingle three things in Jan 6 we're going to talk about here. We're going to talk about the new subpoenas by the Jan 6 Select Committee in the House. We're going to talk about Jan 6 prosecutions and sentencings and attempts to appeal things that have already been sentenced. And we're going to talk about the Jan 6th and the National Archives and the appeal that's going on at the federal circuit. On the Jan 6th committee and the new subpoenas, as you said, we've got Roger Stone and Alex Jones on the heels of the subpoenas from last week. And just to keep track, right, we got to keep a little bit of a scorecard here because everybody's all upset. Oh, Bannon didn't testify and Meadows is holding out and who knows about the other one. And they've interviewed 200 witnesses, 200 witnesses. And not just low-level people. They've gotten Proud Boys and Oath Keepers and insurrectionists and others. And they're even if they never get Flynn, they never get Meadows, they never get Stone or Bannon to testify, they have more than enough. And parts of it have already leaked out to the press to establish the control and command and leadership structure, starting with the Trump organization, the Trump campaign, the Flynns, the Bannons of the world, Kayleigh, the press secretaries, Meadows, the chief of staff, all in a war room in a hotel on the 4th and 5th of January, coordinating with the Proud Boys and the Oath Keepers, whether they were using burner phones and talking to Eric Trump or they weren't. They have enough. They could issue the report like tomorrow if they needed to, but they are in an exercise of diligence and exercising constitutional powers appropriately, holding people's feet to the fire and making sure they're doing everything they can to get the last ounce of testimony out of the people that were at the very, very apex of the command and control structure on behalf of Trump. But no one should be shocked when the report comes out. I think they've said they want to get it out by January or February before January before the midterms. That report is going to be a scathing indictment of Trump, all of the people in the Trump circle, and their involvement with and the cause of the insurrection being the command and control and leadership at the very top of the Trump organization and the Trump campaign. That's what it's going to say. So these are all, I find them really interesting if they ever get one of them to turn. But Roger Stone's never going to turn on Trump. You know, Meadows is probably not going to either. And they're all watching out of one side eye, what happens with Bannon if Bannon really goes to jail. I mean, right now, the Bannon indictment and the future Meadows one is not scaring the crap out of these true believers who are clinging to Trump as tight as they can for now. But it is having an impact on that next level just below them. Flynn is going to go to jail. Bannon will go to jail. This is my prediction. Meadows may even go to jail without ever testifying. But they have enough with the rest. So we're back to the Tokyo Rose moment. Have faith, Democrats. The Jan 6 committee and its bipartisan group are going to issue a report that's going to tie all of this together with or without the ones that we'd like to see their heads on a pike.
Popok, what's going on with the National Archives? We've talked about in the past podcast, the district judge. What was her name again? What was your nickname for
Tanya, her? Hang 'em high Chutkin. Tanya Chutkin.
Order that the Jan 6 committee was entitled to these documents from the National Archives. This was appealed to the DC Circuit. The turning over the documents was temporarily stopped. It was stayed pending, a briefing on the issue. But now the DC Circuit's questioning whether they or even the district court even had jurisdiction to hear it, and whether this is just a decision that the National Archives on its own is empowered to make, and that it shouldn't even have judicial review. Is that possible? I mean, one, I'm happy about that because that means the Jan 6 committee can get these records. But is that possible that the district courts don't even have review over a federal agency or a federal group like the National Archives?
Hey, let me explain why, and I'm going to distinguish it from what's going on in Texas with SB 8, because I want to reconcile a thought that some of our listeners and followers might be having, because we said that it is unconstitutional, and we believe it'll ultimately be found to be unconstitutional that a state like Texas could prevent federal constitutional review of its statutes, in this case, the bounty law and abortion. And that will ultimately be found unconstitutional because you can't prevent a federal court from declaring a state law federally constitutional or not. This is different. Congress, in creating a statute, in this case, the Presidential Records Act, which is 44 United States Code 2201 to 2209, which is post-Nixon, which is how Congress dealt with what they thought would be a future Nixon who would try to hide and destroy presidential records. They created an elaborate statutory scheme that puts the National Archivist. I heard your brother once say, why do we even know who the Postmaster General is? Why are we talking about this guy? Whoever thought about the National Archivist who sits in the National Archive? But this person has an important role under the Presidential Records Act because that person makes the ultimate decision in consultation with the incumbent president, Biden, and with the former president, in this case, Trump, about what records do or don't come out of the National Archive and get used in a lawsuit. And there is within the statute, written by Congress, a provision that says that the decision by the archivist is final and shall not be reviewed except in certain exceptions, which probably don't apply here, by an appellate court. So the question you're asking, Ben, is, can Congress, within its own statute, deny a federal court the ability to review the administrative decision by somebody like an archivist? The answer is yes. What the Congress couldn't do in the separation of powers, back to Texas, is to say that, and the federal court cannot declare this to be unconstitutional. That takes away the job of the federal court and the separation of powers and the checks and balance system. That you can't do. But if I'm a congressional legislative body and I want to create a statute that will not be reviewed by any federal court, not on constitutionality grounds, on other grounds, because Trump's not arguing that there's a constitutionality problem. He's arguing that he's got executive privilege and he holds it, notwithstanding the Presidential Powers Act, the Presidential Records Act. So the three-judge panel, again, two Obama appointees and two Obama appointees and one Biden appointee have said, which they're supposed to, before we even get to the merits of this case, both parties, there is a provision in the act that talks about what jurisdiction we may not have as a court. And courts are courts of limited jurisdiction. They don't exercise jurisdiction and take cases unless they find they have subject matter jurisdiction over the case. So the court is saying, first thing we want you to brief both sides by the November 30th argument, which is oral argument, which is Tuesday, is why are we even in court? Isn't the archivist's decision final? And that panel wants to hear from both, because if they ultimately decide no jurisdiction, the appeal is over. And then Trump's going to have to take an appeal to the Supreme Court to argue that the appellate court's jurisdictional interpretation is wrong, which is actually puts him back on his heels in any appeal. So that's not a bad thing if the court finds lack of jurisdiction, but this is what's called a sua sponte, dropping a little Latin here on the podcast, a sua sponte order of the court, meaning no one raised this issue so far in their briefing, neither side. The judge on its own, sua sponte, is asking the parties to respond to the issue and brief it first so they can decide jurisdiction.
And so if there is no jurisdiction, that would be a good thing for the January 6th committee, because they would get all of these records. So if jurisdiction's the first threshold, then second threshold, we go to all those issues we talked about on the last LegalAF that Judge Chaukin basically ruled the executive privilege claim is a ridiculous claim. We remember the ruling where she said Trump is no longer the president and presidents are not kings. And in our system, the new presidential administration is able to make that declaration or not make that declaration over the executive privilege. And here, Biden administration did not make that executive privilege claim. And Trump's argument, Popok, is just one of the wildest, like strangest arguments too. His slippery slope argument that if the National Archivist could turn this over, just imagine how this will be abused in future administrations where the National Archivist will just turn over these documents to future congressional committees. And to that, I say, good. You're a public official, unless it's
Joke's
some
on you.
national security document, which can't be turned over anyway. You know, these are documents when you're an executive and when you're the president of the United States, these are documents that become public. They go to the National Archivist so that future historians and the public can look at it and analyze your administration to make sure you aren't crooks. And by the way, these are also documents that would otherwise be subject to public records requests anyway. And just because you make the claim of executive privilege, if Biden were to say executive privilege or another Trump administration were to say executive privilege, that doesn't mean it just holds. You know, that means the executive privilege claim could be litigated whether or not there is executive privilege or not executive privilege.
Congress took a lot of time after the Nixon era, a lot of soul searching about what happened in the Nixon White House and how it would never happen again, and establishing new guardrails. And they took a lot of time in the 70s to develop the Presidential Records Act and get what they thought was the balance right between the incumbent president and the outgoing president, and the exercise of the privilege and the role of the archivist, who they put in charge of this process as the head administrator, if you will, and took the court system out of it because they were worried about, individual judges using their own, barometer when they didn't want that. They had set up a statutory scheme and they wanted it abided by. And I know that the Trumpers would like to take a time machine back in time and do a lot of things that are not natural, but one of them would be to, remove the Presidential Records Act from existence. But it's on the books, and it's what controls, and it's what all of the judges, even this Supreme Court, 6-3 right wing, is not going to be able to ignore the Presidential Records Act.
One of the things that concerns me, though, Popok, as I talk it out with you, though, is imagine the other scenario, though, where documents clearly are not subject to executive privilege, but it is abused by a new administration who makes the claim and directs the National Archivist not to turn over certain records. Someone then files a lawsuit basically saying, turn over those records. And then there's an outcome that basically says, you know what? There's no jurisdiction here at all. The National Archivist can make that own independent decision, because our system in many ways is based on the fact that you wouldn't have, for example, the General Services Administrator, the head of the GSA, not signing the basic document that she was supposed to sign. I remember Meidas Touch made a video about her. I'm drawn Murphy, I forget her name. I shouldn't even know her name. It was like something Murphy was her name. Allison Murphy, Ellie Murphy, I forget. But I do worry, though, Popok, that if there is a ruling that a court does not have jurisdiction, couldn't it also be abused where you're now empowering in the ministerial function a National Archivist to do the exact opposite of what they're supposed to do and not archive? That worries me, knowing the precedent that Trump has set with the GSA.
Yeah, I think the first thing you got to do when you're the new president is you got to replace the archivist with your own person, because but if Trump gets in and he puts his own archivist in there, if he gets in again, or worse gets in, I'm not sure there's worse, but there could be. The playing politics with positions that the founding fathers and even past Congresses never envisioned, playing politics with the GSA head, playing politics with the postal general, postmaster general, playing politics with the surgeon general, playing politics with the CDC and the NIH, politicizing viruses and pandemics. I mean, there's going to be soul searching. It's hard to do it in real time. Your brothers do it great. We do it great. We're in real time. But the historical view, the long view of history, which comes 5 years and 10 years and 15 years after academic study and introspection, and then the resulting change in the law, that's going to take time. I know people are like, gotta happen now. Things aren't going to happen now. There is law that's going to be created now that we've got the learning curve of what a Trump can do, that a proper Congress, if it has the time, that's why the midterms are so important, to fix, it will. But you got to take the plane up 10,000 feet and 30,000 feet and look back down in order to make some of these decisions. Presidential Records Act didn't happen like the day after Watergate and the resignation. It happened over a period of time by a Congress who were statespeople that wanted to do the right thing for the country, which is something in short supply today.
Popok, now tell us about these January 6th insurrectionists who pled guilty, who are trying to now take back their plea. They're trying to withdraw their plea. And there also seems to be this kind of cottage industry of far-right GQ peer attorneys who kind of swoop in and try to then overly, politicize the issues and make this about, they inject their wild conspiracies in there. And I'll tell you, a lot of the January 6th insurrectionists, though, have gotten pretty wise counsel. Not all of them, but, the shaman's lawyer, who was very outspoken against Trump but came in there and got a fairly good result for the client, serving very little jail time. And a lot of them had counsel who defended them, again, pretty well and got good results. But now you have all of these, GQ peers. One of the names that comes up over and over again is this guy, John Pierce. And he runs a firm, Pierce Bangbridge, and I'm not sure if that firm still exists or what the status of that firm is. But
he also founded the Constitutional Law Union, what I like to call the Con Law Union.
And and John Pierce, for those who also remember, so John Pierce represented Kyle Rittenhouse initially, before Kyle Rittenhouse actually hired these two able attorneys, who did we say what you want about the case. Rittenhouse's attorneys, defense attorneys, did very good job. Yeah. And even after the case, said all the right things about the legal system and what their roles were. They were very outspoken against, like, Fox News and Tucker Carlson trying to inject themselves into the case.
Called Don Jr. an idiot.
And even Kyle Rittenhouse, has basically said things about these other attorneys who tried to swoop in and do all, and
by the way, Pierce, before you leave, Pierce is the one that put up the $2 million bond from his law firm for Rittenhouse when he and Lynn Wood, there's a name we can't get rid of. It's like a bad penny. He and Lynn Wood were the original lawyers for Rittenhouse. Pierce put up the $2 million. So the question is we'll talk just a second on Rittenhouse, who gets the $2 million bond back now that the case is over? And Rittenhouse is fighting with Pierce because he says that Pierce and Lynn Wood stole money from him and did other things that they shouldn't have done, and that the Rittenhouse family and the new lawyers should get the $2 million. And Pierce is saying, I put up the $2 million. What are you talking about? So this aftermath of Rittenhouse and the fight over the $2 million. But you're right. Once again, as I said before, there's lawyers that frequently sue Trump and are doing really, really well. Then there's lawyers that are, always popping up and are popping up again, like John Pierce.
So we have these lawyers, not just Pierce, a bunch of other lawyers, but I see this time and time again where you have these insurrectionists. They go in front of the court. They pretend to take accountability for their actions and what they did. And then as soon as they leave the courthouse, they basically go and they take to social media. They have a new lawyer who basically says they were coerced. You have I forget what that lady was, though, the influencer insurrectionist lady who was the real estate person.
The real estate broker. Yeah.
The real estate broker. They go on Newsmax and all the TV shows and talk against the judge, which is why I've always said, Popok, that these slap on the wrist sentences are not enough. These individuals need to be tried. There shouldn't be plea deals with them. The book should be thrown at them, and they should get serious sentences, because even when they get the slap on the wrist, they're just emboldened to go out and just continue the conduct. So why do we see insurrectionists who have pled guilty withdrawing their plea?
Yeah, because judges, at least two of them, like Randolph Moss, a Bush appointee, and Dabney Friedrich, who we talked about her last week, a Trump appointee, are starting to question whether the obstruction charge, which is the big hammer in all of the indictments brought against 200 out of the 700 insurrectionists, which is a felony, which carries the greatest possible sentence being brought by the Department of Justice, whether it is constitutionally being applied or properly being applied against people that broke into the Capitol and were insurrectionists. And Dabney Friedrich is this close to dismissing the obstruction charge. And Randolph Moss said the same thing in August about the obstruction charge. Both of them are questioning to the Department of Justice specifically, well, why didn't you bring the harassment misdemeanor, harassing a federal official who's trying to do their job? Why isn't that the proper count for what happened on John 6? Why is it obstruction of justice? Isn't that really properly only when you obstruct the process in a courthouse, in a courtroom? And they're having this debate. So now that's the dog whistle. Now the lawyers like John Pierce are saying, if you've pled guilty to something like obstruction, which the Jacob Chansley, the guy with the furry hat, and two or three other ones, including this MMA fighter, Scott Fairlamb, who's the current one who's trying to walk away from his plea deal and his sentencing by arguing that I pled guilty to a crime that is either unconstitutionally being applied to me or improperly being applied to me, to which our listeners and followers may understandably saying, well, so what? There was an allocution. You stood in front of court. You accepted responsibility. You pled guilty to a charge, and you were sentenced. And all that is true. And generally, if you do all of those things, you are not going to be able to later appeal just because you get new creative lawyers who want to say, ineffective assistance of counsel. Your last lawyer was terrible, or he had you plead to something without you having full information and making informed decisions about your case, and whatever else they're going to argue. But there is, under the federal appellate system and rules, an ability, even after sentencing, for a party to claim that the thing that they pled guilty to was unconstitutionally applied to them. And even the Supreme Court, in a case in 2017, came out, a case called CLASS versus the United States, came out and said the constitutionality of a statute can still be challenged on a direct appeal even after somebody has pled guilty and after they've been sentenced. So that's a loophole that the lawyers like John Pierce are going to drive a truck through and try to convince their defendants, don't plead guilty to that obstruction charge. Look what these other federal judges are doing. They're saying that charge is probably invalid as applied to you. Let's go back and try to unwind this whole scrambled egg and appeal your sentence and let's not plead guilty. But here's the downside. These are all people that pled, meaning they didn't go through a trial. So what are they going to do now? They're going to unwind their plea deal. They're going to, let's say they win. They convince the federal appellate court and then the Supreme Court that the obstruction charge is invalidly applied to them. Okay, there's still other charges in there. Now you got a prosecutor who's pissed off. You got a judge, it returns to the same judge. You got a judge who's pissed off at you. And there's either not going to be a plea deal offered to you. There's going to be a plea deal with lots of more years attached to it. And then the judge, or you're going to go to trial. And then Lord knows what you're going to happen in a Washington, D.C. jury pool with these crazies when there's a trial. So I don't know. We're back to, what is the end game here again? If it's just, these are terrible things, delay, maybe a new president will get in office and absolve you of your crime by way of commutation of your sentence, or by way of giving you some sort of immunity or giving you a pardon. That seems to be the play. Last long enough so that Trump gets back into office. When JFK Jr. shows up at Dealey Plaza, he will pardon your sins. I guess that's it. Is that it, Ben?
These are people who are not well but certainly do not deserve a pass, because there are lots of people who are not well, who don't become insurrectionists and try to overthrow our democracy. But a lot of the lawyers, like the shaman's lawyer, basically said that, and he said it in very kind of crass terms, but that his client is someone who was unwell, who was manipulated by Trump. And I think we see time and time again this continuing, ongoing manipulation and grift off the backs of these people, and kind of a grift on grift on grift. Like they all kind of, this whole right wing echo chamber is like a grift chamber of like a symbiotic grift relationship where they all try to basically fuck over each other in their own little bubble. But at the end of the day, Popok, what I see with the verdict, and we'll talk about it soon, the guilty verdict for the killers, the murderers of Ahmaud Arbery, is that we can, with facts, with truth, with professional prosecutors who do a good job. And I think you see a very big difference in the level of skill in the prosecutors and defense attorneys too, as you look at the trial of the killing of Ahmaud Arbery, and then the trial of Rittenhouse also, and how the facts were presented. But we can, in correct forums, dispel disinfo, cut through it. And trust me, the lawyers who represented the killers threw out every dog whistle imaginable,
every racial trope imaginable.
And it didn't work. And it didn't work. And we'll talk about that in a minute. But first, I want to tell you that this podcast is brought to you by QB. Think about how many hours we spend sitting at our desks or on the couch watching TV. What if you could turn those otherwise inactive times into opportunities to burn calories and get fit? That's exactly what I'm doing thanks to my new QB. That's CUBII. And it's a compact elliptical unit that fits easily under my desk so that I can be pedaling my feet and getting a workout while I'm sitting at my computer. In fact, I am using a QB right now while I'm recording this commercial. QB is whisper quiet, super easy on your joints, and a recent clinical study confirmed helps burn 84% more energy than sitting alone. We all say, I'd work out more if I only had more time, right? Well, QB makes it easy to burn calories and stay active anytime and virtually anywhere. In fact, I set my QB up in front of the couch to burn some calories while I'm watching TV. QB is also a perfect solution for anyone who might be housebound or otherwise needs something to improve circulation and keep active. If you have a parent or a loved one who has limited mobility and needs a way to stay healthy, QB would be the perfect gift for this holiday season. I love my QB, and I know you will too. Take advantage of QB's 30-day risk-free in-home trial. Turn your least active times into your most productive opportunities to stay healthy with QB. Visit QB.com/LegalAF to find the QB elliptical model that's right for you. That's QB.com/LegalAF. That's CUBII.com/LegalAF. Popok, verdicts this week. Verdicts in Charlottesville, verdicts in Georgia, in the killing of Ahmaud Arbery. Talk to me about the Charlottesville verdict.
Yeah, good week. This is the same law firm that handled Charlottesville. The plaintiff's case was handled by the same law firm that did E. Jean Carroll, and also the ACN case we talked about earlier. So these are all good bedfellows that are helping on the right side of justice. So we talked about it last week. We've got the Unite the Right. I hate these rally slogans that formed with 700 people that descended on Charlottesville after in February of 2017, the Charlottesville Council Commission, whatever it was, ruled to remove the Robert E. Lee statute, the Robert E. Lee Confederate statute, from a public square, and then all this united, not the right, it unite. Well, I guess it is part of the right. It united the Oath Takers and the Proud Boys, the neo-Nazis and the Ku Klux Klan to all descend on Charlottesville and do a rally. And there was a counter protest, of course, by sane individuals there. And there was clashes. This is the one that, to recall, if people want to recall, this is the one where after a woman was run over by a car and other people were terribly injured by the Oath Keepers and the other marchers. This is where Trump said, well, there's good people on both sides, like there's good peoples, in the Holocaust between the Nazis and the Jews on both sides of that equation when there wasn't. And so this is a civil lawsuit because the criminal prosecution the criminal process has already worked its way and convicted those people that committed crimes on that side of the aisle, the right side of the aisle. And now what's left is whether the civil case seeking damages and money brought by the victims, the protesters who were damaged emotionally and physically, the family of the woman who was run over by a car, whether they're going to recover in a court of law. And we talked at the past podcast about how nuts this trial was, primarily because many of these white supremacists, neo-Nazis, skinheads, and the like decided to represent themselves. They declined the opportunity to have a public defender assigned to them because they wanted to make a mockery of the justice system, and they wanted to be able, as we said before, to use the N-word in the courtroom and to the jury and tell Holocaust jokes and all sorts of eye-popping things that they did. Of course, the jury was completely turned off by all of this against them. And eventually, there were really two sets of claims that were brought by the plaintiffs' lawyers and the plaintiffs. One set was under Virginia state law on conspiracy and tortious and torts related to emotional distress and that type of thing, seeking both actual damages and punitive damages for this bad conduct to punish them for what they had done. But then there was inside there a novel use, and really the first time in a long, long time I've seen in a civil case, the use of the KKK Act of 1871, a federal statute that was created during the restoration process or era in American history after the Civil War to stop primarily freed slaves from being executed by the KKK when they tried to exercise their 14th Amendment rights and the other rights that were granted to them after they were emancipated. But it's still on the books, and you can use it in context other than, 1800s and slavery and the KKK. And that's what the plaintiffs' lawyers tried to do. And there are other penalties that are associated and injunctions that you can get as part of the KKK Act of 1871. So as part of our LegalAF lesson here on jury trials, and we talked about deadlock juries and hung juries and mistrials. We were talking about Rittenhouse and what happened there. Here, the jury reached a verdict on the state of Virginia laws related to conspiracy and awarded $26 million to the plaintiffs and against these assholes. And now, of course, the plaintiffs have to try to collect this money and go pick up trucks and shotguns and whatever these people own, which will now be forfeited to pay for their judgment. But what the jury was not able to reach a conclusion on and deadlocked were on the 2 counts or 3 counts under the KKK Act of 1871, which presents a novel resolution. The verdict is the verdict on the Virginia state claims, and the judgment is the judgment. But on the counts where the jury did not acquit or didn't find liability either way, and just threw up their hands, even after being instructed by the judge in a version of something we call the Allen charge, where you tell the jury, go back and deliberate more, try to get it right. I know it's hard, but try to get it right. The jury still said, we can't figure it out under the KKK Act of 1871. The plaintiff's lawyers are going to be able to try a whole new case with a whole new jury, and now with the benefit of the learning curve of learning what they did right in the courtroom in the presentation of the case and what they could improve on. It's almost like they got a mock jury on the KKK Act claims, and they've already declared on the courthouse steps that they're happy with the victory, but they're going to go back and try another case in the next year with a new jury on the KK Act of 1871. Now, here's one thing that I want our listeners to understand. You can only be hit with damages once. So if there are damages that compensate you for your injury, whether it's emotional, economic, or otherwise, or you're awarded punitive damages, at least on the economic part of it, you can only recover once. Even if you have 10 claims, your economics are made whole once. So they're not going to be able to recover again under the KKK Act their economic damages unless there are different economic or emotional damages that are covered by the KKK Act that are not covered by Virginia law. And so there'll be an offset or a credit for the economic damages, even if they win the second trial. However, it does give a new jury the ability under punitive damages to nail them again. And that's the higher number of damages. Once they find some credible actual damages, this new jury could hit them again on another round of punitive damages, which would increase the $26 million judgment even higher. But let's be frank. These guys don't have a pot to piss in or a window to throw it out of. They're not going to collect $26 million of it from them. They're going to get whatever they can. The purpose of this case was not necessarily to collect money. It was to draw a line in the sand and to say enough is enough, and that people like this are going to be both prosecuted and they're going to be put through the civil process and have judgments and have their lives ruined economically as a result of their actions.
That's the thing. You have the Alex Jones of the world and these individuals who go into the courtroom in Charlottesville and make a mockery out of the process. But I'll tell you what, these plaintiffs and their lawyers are going to be garnishing your wages, putting liens on, property where allowed by law. They're going to be,
towing their tow truck away.
Yeah. So get ready for that. And you know what's going to happen when that process starts happening? All of these individuals who made a mockery of it, they're going to go, oh shit, do we need a real lawyer now? Do we need to focus on it? One, they may not get a real lawyer. And two, they'll try to, can we overturn it? Is it too late to appeal? And it will be at that point too late to have done anything. And so, I think that, as you said, Popok, no one's going to recover fractions of this $26 million. But at the end of the day, anywhere these individuals, these horrible, racist, disgusting individuals go, they're going to have this hanging over them for the rest of their lives. And finally, Popok, take us from Virginia further south in Georgia, where the killers of Ahmaud Arbery were found to be just that, killers, murderers, found guilty on all counts. Other than that headline, Popok, any further observations?
Yeah, a number of them. I think that this should give all of our followers and listeners some degree of confidence and relief that the justice system, when jurors, no matter their color, no matter their background, are presented a proper case where a judge doesn't have his hand on the scale, where there's video evidence, where the testimony of the witnesses help the jury to deliberate properly, that even there, with a proper prosecutor, the jury is going to ultimately do the right thing, and that we should have confidence in our jury system when the playing field is leveled. But this case has a lot of interesting nuances. You start with the fact that the prior prosecutor is now sitting in jail, or she bonded herself out, because the Republican governor of Georgia and the Republican attorney general went after her because she failed to prosecute the case at all. These three guys, Travis McMichael, his father, Greg McMichael, and Roddy Bryan, their neighbor, were not even arrested for 78 or 79 days because this prosecutor, who was friends with Roddy Bryant because he was an investigator that worked in the prosecutor's office, because all three of these guys had law enforcement background, which made them yahoos and vigilantes because they thought they worked in law enforcement. They could do anything. But because she favored Roddy, she turned a blind eye to all of the facts in the video. And it wasn't until Ahmaud Arbery's mother brought a civil case back to the power of civil cases that the governor and the attorney general took a look at what happened. because she brought a civil case against the prosecutor, right? This woman, Jackie Johnson, sounds like an Elmore Leonard novel. So Jackie Johnson decides that she's not going to bring any case against the three people that murdered Ahmaud Arbery. So the mother brings the civil case, the governor, the attorney general, Republicans look into it, and they get an indictment against Jackie Johnson just a couple of days after the verdict. She has to turn herself in. There's a mugshot online. She's wearing like a clutch of pearls as she's being processed and bonded out. And she's being prosecuted for two things. One, that she has violated her oath of office because she has not properly exercised her role as a prosecutor by showing favoritism. That's a felony if that's proven. And it sounds like it should be. Then she's also guilty of or been indicted for obstruction of a public office, which is a version of public obstruction of justice, which is a minimum of 12 months in prison as well, because she bent over backwards to help her buddy, Roddy Bryant, who worked at her office, to avoid this. The other fascinating thing about the jury and the jury verdict, where you had 12 jurors, 11 white men and women, one person of color, one black person, in a county, in a community that's 27% black. Okay, but that's the jury that was selected. And the counts that you and I talked about, which were so properly charged by the new prosecutors and so different than the Rittenhouse case, were malice murder, a unique state of Georgia crime that doesn't exist in Wisconsin, felony murder, which is if you're committing a felony, in this case, false imprisonment of Ahmaud Arbery, by surrounding him with three people, and a pickup truck, and blocking his exit, and cornering him, and to use the language of Greg McMichael, trapping him like a rat. That was the testimony. That was the sworn testimony to the police when he was arrested. That when you do that and somebody dies as part of that felony, it's a felony murder. And the other interesting thing is only one person pulled the trigger, right? It's Travis McMichael pulled the trigger on the shotgun, a 12-gauge shotgun, twice, and killed Ahmaud Arbery, murdered him. But the other two were convicted equally for felony murder and malice murder under the state of Georgia's penal code. And the prosecutor, I thought, had, although it was a little bit lighthearted, it got the point across to this jury. I mean, you got to think after 3 weeks in trial, she knew her jury. She said, it's like a football team during the Super Bowl. Everybody gets the Super Bowl ring. The quarterback gets the Super Bowl ring. The water boy gets the Super Bowl ring. The towel attendant gets the Super Bowl ring. Everybody gets it. And everybody here gets the murder conviction because they were all involved with the ultimate death. Now, what did the judge do right? The judge kept out certain evidence that would have prejudiced the jury potentially against Ahmaud Arbery. There's a couple of things. There's video of Ahmaud Arbery inside of some homes that were being constructed late at night. There's no doubt that was him on the video, but who cares? That's not a death sentence. The fact that somebody is curious about a house under construction and wants to wander around in there, that doesn't lead to the death sentence or death penalty in any state. So stuck with that and stuck with some other rulings by the judge, what did the defense do in a really disgusting fashion in their closing argument, which I assume backfired, is they used every racial trope that they could think of about almost like runaway slaves and the language in cartoons that were used, terrible racist cartoons that were used during the 1700s and the 1800s. I thought I was watching like Django. She actually said the Laura Hogg, whatever her name is, as the defense lawyer for one of the defendants, actually said that Ahmaud Arbery was armed. He was armed with his fists. I don't think he wasn't armed. And he wasn't just a jogger running through a street with clean and neat shorts and shoes. He had long, dirty toenails. By the way, they only know he had long, dirty toenails, if that's even the case, because of his autopsy, because he was murdered. And he had dirty shorts and dirty socks. So what were the defendants to think when he's running through their all white neighborhood? She didn't say that last part, but that's what she was trying to say. And that gave them the justification to do a citizen's arrest. Another interesting aspect of the case that didn't get much press is that at the time of that incident, the state of Georgia had on its books a citizen's arrest statute, which empowered civilians to act like they were Yahoo cops and arrest people if they suspected a crime. You know what happened since the Ahmaud Arbery prosecution and what even the Republican legislature and governor have done about that law, Ben?
What happened?
Took it off the books. Even in Georgia, even with the Republican state house, they think that law went too far. And they did not want more Ahmaud Arbery's being murdered by people trying to execute what they thought was a proper citizen's arrest. But the defense trying to blame Ahmaud, they actually said at one point in their closing argument, none of this would have happened. It's all Ahmaud Arbery's fault. All he had to do when he was trapped by 3 white people with a shotgun and the doors of a pickup truck blocking his exit, all he had to do was just sit there and wait, and the cops would have came and would have sorted this all out. I am not making that up. That is their closing argument. Blaming the victim because with fear in his eyes and in his heart, facing 3 strangers, white guys, yelling and screaming at him. One of them testified that he screamed at Ahmaud Arbery, "If you take another step and move, I'm going to blow your effing head off." That he was supposed to just sit down like a good you-know-what on a sidewalk and wait for the police to arrive. And if he hadn't done that, then there wouldn't be a murder at all. Thank God that jury had a brain in its head, a good judge on the bench, a skillful prosecutor in Lisa Dunikoski, who did a masterful job in the cross-examination of Travis McMichael, who took the stand in his own defense. And the result is justice.
Justice served and justice learned on this edition of the Meidas Touch podcast. Legal AF. If it's Saturday, it is Legal AF. If it's Sunday, it is also Legal AF, except Saturday it is Legal AF Live, where you get to join Popok and myself in the YouTube chats. Make sure, if you're listening to this podcast too, you can subscribe to the YouTube channel. It's the Meidas Touch YouTube channel, where we do these live broadcasts from on Saturday, and they replay after. And so lots of people do both. They watch the live and they listen to it the next day. There's a lot of information to unpack. These are hour-plus long lessons, today verging on 2-hour-long lessons on law. You know, and we've done so many of these, Popok. I mean, you said earlier jokingly, but you're right that we've basically have gone through together with our legal AFers out there, you know, a little bit more than a semester of law school out there. And we'll keep bringing you through law school, our law school. We should maybe print even like legal AF, like certificates, but the lawyer in me, though, doesn't want to see some risk in doing legal AF law certificates, but we could figure out a creative and fun way to go about doing that, because I think that'd be fun for all the people who listened out there to acknowledge that they've listened to X amount of hours and have learned a lot about the law, although that won't make you licensed to practice law in any state, but probably make you a better lawyer than Mike Lindell. Popok, enjoy the rest of your trip. Enjoy the rest of your travels, and always a pleasure hosting this with you each weekend.
You and I started this, it's hard to believe, 35 weeks ago. And I know you and I are both, we both pinch ourselves and each other now that we've seen each other. We pinch ourselves and each other about what has been accomplished, not just by you and I, because as I joke, but only half in jest. This would just be like you and I on FaceTime on Saturday mornings or Saturday nights if we didn't have an audience of enthusiastic people. And we wouldn't have gotten this far. This would have been a 5-episode pilot, like, okay, it didn't work. Let's try something else to activate the Democrats out there and to talk about the law. But this thing caught fire, yes, because you and I enjoy doing it, and I think that rubs off on our listeners and followers, and we're doing a service, but it's because of them. If it wasn't for everyone on our YouTube channel with us tonight and on Facebook later, and when we tweet it and through Periscope later in the day, and then download it tomorrow morning or at midnight Eastern time tonight on all the podcasts. And then the biofeedback, you talked about an echo chamber of craziness. We have the opposite. We have an echo chamber and a biofeedback of really enthusiastic people that hang on our every word. And we take that responsibility really, really seriously. And I love seeing you every day. But if it wasn't for them, you and I would do this every other week.
No doubt about it. And special thanks to our sponsors. Fiverr, go to Fiverr, Fiverr.com. Use the code LegalAF. Aura Frames, go to AURAFrames.com. Use the code LegalAF for discounts there. For Calibrate, go to joincalibrate.com, joincalibrate.com, and then use that promo code LegalAF. And for QB, go to cubii.com/LegalAF. Of course, go to the MeidasTouch.com site and get the discounts off your Meidas Touch merch. We appreciate you so much. Go share this legal knowledge now with your family, with your friends, with your colleagues, with the world. We will see you next week, same time, same place. Ben Popok signing off. Special shout out to the Meidas Mighty.